Good morning, I'm Lucas. Today I'm going to tell you about the family relations in light of the legal systems. So I'll present you the facts. In 1889, Elmer Palmer, a young man, is convicted for poisoning his grandfather who wanted to remarry. The motive of the young man was not having his inheritance share reduced. The grandfather's two daughters sued him to contend his inheritance with Elmer. My opinion coincides with that of the judge who issued the sentence, determining that besides the prison sentence, the young man would not have the inheritance. According to Italian legal system, there are three theories which may legitimate the use of the penalty by the state. Firstly, according to the retributive theory, which is an absolute theory and is not bound to any further purpose other than retributing of the evil inflicted by a person to another person or to society. Secondly, the deterrent theory is one of the two relative theories as this assign a further purpose to the penalty. If this case is the deterrent theory, that is, the purpose to orientate the consociate's behavior, leaning on intimidation expressed on the penalty's content in order to work as a deterrent to consociate's crime drives. Lastly, the reformative theory, a relative theory which conceives the penalty as an individual preventive tool to the offender so that he does not commit another offense. This theory is based on three actions. The first is neutralization, the second is intimidation, and third is resocialization. It's important to know that none of these theories impose themselves by superiority or rationality, as the legitimation of the penalty varies according to the state where the problem poses. I'm aware that some people may disagree with me on some aspects. For example, they may think that when an exception is not provided by the law should be followed by the judge within the letter or statute. Another counter-argument could be that the judge cannot issue a ruling contradicting the will expressed by the testator. Finally, Elmer was already punished through criminal conviction, and depriving him of the inheritance would amount to charge an additional sentence to a convict. However, I single out three counter-arguments in this case. Firstly, the rational legislator argument, which states that the historical legislator ignored the issue, but when taken into account, he would make an exception to exclude the murder from the inheritance. Secondly, the law did not specifically address to the circumstance because the intention was to provide a discretionary margin to the judge. And lastly, a given precedent which has certain similarity was not applicable to a case of the issue. So there has been much discussion about this case. Mainly, the philosopher of law Ron Dworkin, which on his book Laws and Empire supposes two theses, a right one and a wrong one. I maintain that the author is wrong when he turns the discussion between just Gray and Earl into a clash between two philosophical doctrines. Moreover, the grounds of the judgment state that nobody must take advantage of his own wrong, not linking the term wrong to the morals or to natural rights more than the term unjust damage of the Article 2043 of the Italian Civil Code implies. Any questions?